Let's go right to the bottom line. On average, how much money are workplace discrimination lawsuits worth, and when should you pursue your case? These are important questions. I'm going to give you honest answers. My name is Branigan Robertson, and I'm an employment lawyer. Before I go back to the whiteboard and detail all of this out, I have a few important things to say.
Jennifer Rodriguez thought it was obvious. She was clearly pregnant when she was hired by the Bendinelli law firm as a legal aid. Flagrant case of pregnancy discrimination. Bendinelli law firm was ordered to pay $30,000 in damages to Rodriguez.
First, please realize that there is not an easy answer to this question. You're probably just thinking, well, just give me the statistics, Branigan. Well, quality statistics for something like this don't even exist. Why? Because 95% of cases with private lawyers like me settle, and those settlements are confidential. So if you really want an honest answer to how much money discrimination cases are worth, then keep watching this video. I promise to explain how the legal system values these cases. But to truly understand the answer, you'll have to pay close attention.
She was discriminated against because she's white.
This principal is getting more than $300,000 after a federal jury ruled the school district discriminated against her for her race.
Second, we are going to answer the question by exploring the topic from 3 different perspectives. First, if you were discriminated against unlawfully and then fired from your job. Second, if you quit your job after experiencing discrimination. And third, if you are still employed but experiencing discrimination at work.
A jury today awarded Wendell Brown more than $500,000. He sued the city, claiming he faced racial discrimination and retaliation in the workplace.
Next, this video does not cover the legal definition of unlawful discrimination. Believe it or not, but not all discrimination at work is illegal. If you want to learn more about that essential subject, I highly recommend that you watch my video where I explore that subject in depth before you decide to contact a lawyer. I'll put a link below in the description.
The city woman won a multi-million-dollar lawsuit against AT&T for religious discrimination.
The jury then agreed the company owed Bashir $120,000 in lost wages and pay $5 million in punitive damages.
Fourth, even though I'm a California lawyer, I made this video for everyone in the United States. If you're not in California, this video will give you an analytical framework to understand how employment law approaches damages. And more importantly, it will raise questions that you will need to get answered by a lawyer in your state. If you are in California, this video is not legal advice. It simply lists the basics on how damages work. To get an idea if you have a case and how much it might be worth, you need to call a California lawyer. Here's my contact information if you think I'm worthy of that phone call.
And jurors agreed with her version. Wednesday, they ordered McPadden's former employer, Walmart, to award her more than $31 million.
Finally, each part of this video builds upon its previous parts, so don't skip ahead. Watch it all the way through.
Rosario Juarez was running this auto parts store and she was pregnant. And she says her boss had a big problem with that and a jury agreed. Juarez filed a civil suit alleging pregnancy and gender discrimination. Hours ago, it awarded Juarez a stunning $185 million in punitive damages.
We are first going to examine this entire subject through the perspective as if you were fired. If that's the case, you can collect 5 types of damages. First is your lost wages, next is pain and suffering, then punitive damages, attorney fees, and then sometimes the intangible things can increase your leverage. Let's talk about lost wages first. Lawyers call these economic damages. These damages look at your past lost wages and your future lost wages. And the best way to explain this is using a nice, easy example with round numbers. So let's assume a hypothetical that you are making $50,000 a year at your job. Then you get a new boss and he discriminates against you and fires you unlawfully. Okay, well, you're not making $50,000 a year anymore. Now let's say you were unemployed for an entire year while you looked for a new job, and then you found a new job making $30,000 a year right at the start of the second year. Then 2 years to the day from when you were fired, you go to trial in your discrimination case and you win. Okay, how much would you win? Let's look at your past lost wages first. In the first year, you were completely unemployed, making no money. So you lost $50,000. In the second year, you got a new job making $30,000, and so the differential between what you were earning and what you're now earning is $20,000. Then you had your trial and you won. So your past lost wage loss is $70,000. All right, so now let's go look at your future lost wages. Okay, $70,000 is not the end of our story, not at all. We next have to look at our future lost wages. Your lawyer will hire an economist who will run all sorts of fancy calculations and will come up with a future projection as to what you would have earned had you not been unlawfully fired. For simplicity's sake, let's assume your economist projects that each year for the next 4 years, you're going to get a raise of $5,000 per year. So 4 years from the date to the trial, you'll be back to earning $50,000 a year. So in year 3, you got a raise of $5,000, so you're now making $35,000. The differential between what you were earning is now $15,000. Year 4, you get another raise. The differential is $10,000. Year 5, you get another raise. The differential is $5,000. And in year 6, you get another raise of another $5,000, bringing your earnings back to $50,000. So there's no differential. If you add up all those future wage losses, that's $30,000. So then you add your past lost wages of $70,000 with your future lost wages of $30,000. And in our hypothetical example, your total economic damage picture would be $100,000. Now, obviously, this is an oversimplified example, but it should get your wheels turning as to how lost wages factor into discrimination cases. Now, the value of these cases does not just depend on how much money you made or how much money you lost. We also factor in pain and suffering. These damages are awarded to employees who receive significant emotional distress injuries as a result of being the victim of unlawful discrimination. Emotional distress injuries are not something that you can make up or fake. I mean, you're evaluated by experts who testify in front of the jury. These damages are very real and in severe cases are usually several times larger than your economic damages. But seriously, Branigan, how do you put a dollar value on hurt feelings and emotions? Well, we hire experts, and those experts testify as to your behavior. They talk about your identity change. They talk about your change of behavior before and after. They talk about whether you went to seek professional psychological help. And we build a case, and we present that case to the jury, and the jury decides how much money you get or how much money you don't get. So to continue with our hypothetical case here, you won $100,000 in lost wages. Let's assume that the jury decides that your discrimination was really bad and they award you $400,000 in pain and suffering damages. So far, even though we're not to the end of our story, you now have $500,000 in damages in your verdict. Next are punitive damages. Everybody's heard about punitive damages. These are the damages meant to punish the bad company to deter it from acting badly again in the future. But punitive damages are, well, frankly, very hard to win. You have a much higher burden of proof. Your lawyer is going to have to convince 12 people in a jury box that the company discriminated against you with malice, oppression, or fraud. And that is really hard to do. Everyone thinks that their case is worthy of punitive damages, but statistically that's just not true. In my estimate, I would say in less than 5% of discrimination cases where the plaintiff wins, the employee, are punitive damages awarded. However, if you do win them, they can be high as 9 times your compensatory damages. That's what the Supreme Court has set the upper limit as. So in our hypothetical case, where we've won $100,000 in economic damages, $400,000 in pain and suffering, you could win, that's $500,000, 9 times that. In theory, you could win $4.5 million in punitive damages. However, when good lawyers like me evaluate cases, we don't even consider punitive damages because they're pretty much very speculative. But let's assume that the discrimination that you face in our hypothetical verdict was really bad. So they decide to award you $1 million in punitive damages, bringing your total verdict up to this point to $1.5 million. Next, let's talk about attorney fees. In discrimination cases in California, if you go all the way to trial and you win your discrimination case, the law permits you to recover your attorney fees on top of the other types of damages that the jury awarded you. While this doesn't directly benefit you, the client, especially if the case goes all the way to trial and you win, this absolutely directly benefits the client, the employee, if the case settles. Why? Because 95% of cases settle. And why do they settle? Because of leverage. Here's how this works. Let's say you go all the way to trial and you win, but you only win a small amount, say $25,000. That's a small employment verdict. But the company would still be on the hook to pay your lawyer on top of that $25,000 verdict. That could be 7 figures depending on your attorney's hourly rate and how many hours they worked on the case. So this dramatically increases your leverage, especially because you're probably paying your lawyer on a contingency fee, meaning you're not paying any money out of pocket for the lawyer. But if you win, the company is going to have to pay your lawyer on top. That increases your settlement leverage, and that dramatically benefits you. How much? It totally depends on from case to case. But attorney fees are very powerful in discrimination cases. Settlement in discrimination cases is all about leverage. Obviously, the more leverage that you have, the more money you, in theory, will settle your case for. This part of the video ignores the formal boxes of damages that we just discussed and focuses on the intangible points of leverage that can dramatically increase the value of your case in settlement. So we'll first talk about the facts, then we'll talk about the honesty of the parties, then media coverage, then the temperament of the parties, then insurance, and finally the quality of the attorneys. So first, the facts of the case. This revolves around the facts of what actually happened to you. How bad was the discrimination? When presented to a jury, will they be furious with the company? Or are they going to think you're embellishing your claim a little bit to try to get money? Next, honesty. Honesty is always the best policy. Did you tell the truth during your deposition? Did you tell the truth to your lawyer? Does the company tell the truth? When one side lies, it increases the other side's leverage. Every single time one of my clients has lied to me or lied under oath, it has dramatically decreased the value of his or her case. So please, if you call me, you better tell the truth. Next, media coverage. Is the media coverage a genuine threat in your case? Honestly, this is rare, but when it truly exists, it can increase the value of your case, sometimes dramatically. Next, temperament. What's the temperament like of the person signing the check? This is a huge factor in the value of your case. Is it an emotional doofus who would rather sink his or her company than settle a discrimination case? Or is it a rational business person who will make a prudent business decision? It depends from case to case. Next, insurance. Does the company have an insurance policy that covers your claim, or do they not? What's the policy limits of that claim? What's the adjuster like? Next, your attorney. How good is your attorney? How good is the company's attorney? Believe it or not, but this has a huge effect on the value of your case. Aside from the facts of your case, the single largest variable that contributes to getting a good settlement is the quality of your lawyer. So choose wisely. All right, let's pretend in our hypothetical case that it didn't go to trial, but it settled on the day before trial. Let's say that the company has a good insurance policy. You were an incredible witness during your deposition. The facts of the case are truly appalling. The company lied multiple times under oath, and you've got a great lawyer. In that case, it is completely plausible for somebody only earning $50,000 a year to have a discrimination case settle for over $1 million. It all depends on the case. every case is dramatically different. That's why we can't give you a straight up number if you were fired and what your case is going to settle for. Every case is different, so you need to call a lawyer in your state. So far in this video, we've only talked about people who were fired. Now, let's talk about the folks who quit their job. Generally, if you quit your job after being discriminated against, you can still file a lawsuit, but there is one very, very big problem. Unless you can establish that your resignation qualifies as a constructive termination, you cannot collect your lost wages. The law establishes that if you voluntarily quit your job, you are not entitled to recover economic damages. Okay, well, what exactly is a constructive termination? According to California law, a constructive termination is when, due to the employee having a legally protected characteristic, such as race, religion, disability, age, etc., the employer makes the working conditions so intolerable that a reasonable person in the employee's position would have had no reasonable alternative except to resign. Now, most people who call us think that they qualify under that standard, but honestly, it's very hard to win a constructive termination claim. Judges hate them, juries hate them. As a result, it's hard for people who quit their job to find a really good lawyer to pursue their case. Now, I've taken constructive termination cases, but I'm very picky, and I have very good reason to be that picky. If I'm going to invest thousands of dollars of my money and hundreds of hours of my valuable time into one case, I need to be confident that I'm going to recover enough money to make it worthwhile for my client and for my firm. Well, you're probably asking yourself, okay, I can't get my lost wages, but can I get pain and suffering and punitive damages and those attorney fees? Yes, even if you quit, you can recover pain and suffering, punitive damages, and attorney fees. But unless extraordinary circumstances exist, it's usually a losing strategy. Well, why? Because lost wages are measurable and easily understood by judges, juries, experts, and the opposing lawyers. Alone, pain and suffering damages are very touchy-feely, and punitive damages are speculative and rare at best. In my opinion, lost wages are the key that unlocks those other types of damages. So, is it worthwhile to file a discrimination lawsuit if you quit your job? Maybe. I've taken constructive termination cases before, and I've settled them for a lot of money. But in those cases, we had excellent proof that the working conditions were totally unacceptable. And I was 100% convinced when the client called me that any reasonable member of the jury in a similar situation would have resigned without hesitation. But those cases had extraordinary circumstances. So if you are in California and you believe extraordinary circumstances apply to you and you quit your job, feel free to contact my office for a free consultation. Hey, quick interruption. If you're finding this video to be helpful and useful, please give it a thumbs up on YouTube and subscribe to my YouTube channel. Also, if you know somebody who's going through discrimination at work right now, share this video with them. They will thank you for it. All right, let's get back to the video. Now let's talk about our final perspective. If you are still employed, but you're experiencing discrimination. If you're still employed, you are still earning your salary, your commissions, or your hourly wages. So unless you were denied a significant raise due to the discrimination, or your pay was cut dramatically, you haven't lost a lot of money yet. This situation is very similar to the constructive termination scenario we discussed just a minute ago. This makes it really hard to pursue a lawsuit if you are still working at the company. Now, there's always exceptions to this, but generally, if you are still working at your employer, lawyers like me will tell you one of two things, or both. One, complain about the unlawful discrimination in writing. Now, if you are going to complain, I highly recommend that you watch my video on how to complain properly at work. Legally speaking, it is very important that you complain correctly, so I strongly urge you to watch that video now. Next, we also tell people to call us back if they get fired. You're probably thinking, call you back after I get fired, but then it's too late, my job will be gone. I understand. Unfortunately, the tools that the law has given employment lawyers like me generally are not effective at stopping bad behavior at work from continuing. These tools that we have are far more effective at pursuing justice after the fact. Why is this? Because people are emotional creatures, and lawsuits are like throwing gunpowder on a campfire. If you sue your company while you're still there, you will paint a massive target on your back. Nobody's going to want to see you succeed. The company will want you to fail. They will watch you with a microscope and document every perceived failure. So is it worthwhile to file a discrimination lawsuit if you're still working for your company? Generally, we recommend waiting until you are fired to pursue a case, but like I said before, there are always exceptions to the rule. So if extraordinary circumstances apply to you, don't be afraid to call a lawyer for a consultation. So in conclusion, the ultimate question becomes, should you pursue your case? Well, I can't answer that question for you in a video because I don't know you, I don't know the facts of your case, and I don't know what's important to you. But I can say this. If you are able to find a good lawyer that you trust, who believes in your case and is willing to invest time and money into the case, then you should probably pursue it. Because for the most part, lawyers like me only get paid if we win. Unless somebody has a lot of money and they're willing to pay us by the hour, we simply don't take cases unless we believe we can achieve a great result for our client. Anyway, I hope you found this video to be helpful. If you think I'm worthy and you're in California, don't be afraid to reach out to my office for a free consultation. We handle discrimination cases every single day. That is all I have for you. I hope you have a fantastic day.